This training session will focus specifically on the roles and responsibilities of county governments in affirmatively furthering fair housing. Also presented will be best practices for coordinating county housing policies with municipal housing plans. Just a brief bit about Kevin Dworka, our speaker here today. Kevin is a land use and economic consultant specializing in the revitalization of the state's neighborhoods, waterfronts, downtowns, main streets, and train stations. Kevin is headquartered in Manhattan and offers a unique combination of development advisory services, including economic analysis, land use, guidance, and litigation support. He has conducted housing studies in a broad range of communities in the state, including the New York City, Yonkers, Ossining, Newburgh, Albany, Kingston, Croton-on-Hudson, Southold, and Baldwin. He also provides regulatory guidance and training in fair housing compliance to local governments, professional associations such as the County Attorneys Association and the New York State Association of Counties, as well as real estate developers. We're very pleased to have Kevin with us here today. And at this time, I'll turn it over to Kevin Dworka. Thank you, Kevin.
Thank you, Stephen, Patrick, Lisa, for extending the invitation to participate in this course. I am delighted to address this topic. I wear a lot of different hats, as some of you know. I see a lot of familiar names in the Zoom mix here. But aside from being a land use and economic consultant who advises localities on planning projects, a large part of my practice also involves fair housing enforcement. And at times I'm brought in on litigation suits, and I'm there as a technical advisor. Sometimes I'm enlisted by localities to help them draft their affordable and fair housing policies. And other times, I'm kind of brought in to provide training in the aftermath of a legal settlement to culpable parties. And in those cases, I'm not exactly the person that folks want to see. It's a little bit like going to detention, but it's also an opportunity for some healing to occur after a conflict has unfolded over fair housing. And my goal in presenting this information to you is, in fact, to preclude county governments from ending up in a situation where they are in court, to avoid situations where you are found to be liable for violating fair housing laws, and to help you proactively develop the policies and laws and administrative procedures that align with federal and state and county regulations to ensure that we really do have an equitable allocation of housing resources, and that we live up to the goals that were adopted in the Fair Housing Act. So I'm going to share screen here, and here we go. And just to sort of go over the agenda, which I think some of you may have received yesterday, we're going to open part one by talking about fair housing laws at the federal, the state level. And I'm also going to touch upon the enforcement channels and the enforcement criteria. So that's sort of our foundation. And then from there, we're going to move into three conflicts. I'll talk about the Garden City legal dispute over multifamily zoning. We'll talk about the dispute in Westchester County over the allocation of HUD monies. We'll talk about the use of community preferences in the administration of affordable housing lotteries in New York City. And we'll sort of, develop some strong takeaways from each of these conflicts, and then use that along with what we've learned in part one in terms of housing law to look at some of the ways in which county governments can follow best practices in terms of housing policy design. And specifically, I'm going to talk about how you can analyze your housing needs and plan for increases in the supply of housing, or be proactive about educating your localities, helping them with adopting certain types of housing laws or funding housing development. We'll talk about the marketing of housing units, and then also too, how you can be a part of the enforcement process. So here's our agenda. And before we dive into part one, I realize we have a relatively small group. I realize most of you are kind of not visible on the screen, but I wanted to just open the floor for a moment before we got in here, just for folks to contribute to the question of, well, why do we need fair housing laws before we dive into part one? And maybe, and I'm going to ask you to be brief here and just simply state your name, and you can talk about a particular issue in your community or your county or something you've experienced or something you may know from a more academic perspective of why we need fair housing laws. But before we get into getting all into the nitty gritty, I just want to open the floor here. So anyone have any immediate reactions here as to why we may need fair housing laws? Just unmute yourself and go ahead.
I had one that jumps out at me, and I'm Erin Cousins, and I work for Orange County Office of Community Development. And I don't know that much about the fair housing laws, but I know that the communities that we have to deal with and work with often look very sort of segregated. And so if the patterns of the housing patterns look a certain way, there must be something behind it. And so I always think of fair housing as a tool to kind of address the fact that there is clearly inequitable housing that we can see.
Right, very true. Other thoughts about why we may need fair housing laws? Okay, I'm just going to move to the answers. And I came up with 4, and I'm sure, that as we go through this presentation, you'll probably be thinking about other ones. But first and foremost, and we'll get to Erin's point in a second, but first and foremost, just to address the enduring discrimination in the sale and rental of housing. And I think we are aware of the ways in which racism can manifest in ways that are more subtle and that are not always so easily detectable. We may have situations where folks meet with a real estate broker and they are directed to housing in one part of a county and not another part of a county based upon the observations that the broker makes about the racial identity of the home seeker. Some of you may be aware of the long and robust investigation that Newsday did about discrimination in the real estate brokerage industry in Long Island, and really showed the significant variation in the ways that real estate brokers engaged Black and Brown and Asian applicants versus white applicants for housing or for home seeking. So that's first and foremost. We still are experiencing the residual effects of institutionalized and systemic racism on the basis of race and also on the basis of other identity characteristics, which we'll talk about. A second reason for our fair housing laws is because we have a very high cost burden, especially for lower income residents, with regard to how much of their income they're spending each month on housing costs, whether it's in the form of rent or in the form of mortgage payments. And as a way of providing relief on some of that housing cost burden, we have a host of different types of federal and state affordable housing programs, but we need housing laws to really help us understand what's the right way to allocate those limited resources. And our third reason here for why we have fair housing laws really relates to the experience of living in one's home and the desire to live in a state of dignity and safety and accessibility. And so we need protections to ensure that tenants of multifamily buildings or single family buildings, are not receiving harassment from landlords or from their neighbors, and that the quality of the housing is good too, that there is accessibility for people of various abilities to be able to enter their home, to use their home to the fullest extent. And then lastly, and this speaks to the comment made by Aaron Cousins, to forthrightly address the perpetuation of racial segregation through zoning practices, through funding allocations, and through tenanting. It would seem as though we've come a long way since the 1960s civil rights era toward being more open-minded, being able to embrace diversity, being able to integrate our social networks, our places of employment. And yet, when we look statistically, geospatially, at the racial demographics of our regions, in many places, including New York City, we are actually even more segregated in many ways than we were 50 years ago. And we see this a lot in our school districts, especially. We see this a lot in some of our suburban outlying areas where we look at the concentrations of certain racial minorities in one part of a county and other folks in another part of the county, and little do the two meet. And that segregation, that has a cost, not only psychological cost in terms of what it means to be a child growing up in an environment where there are folks of one kind that live one place and folks that look like you that live in one place, but it also has an economic and social service cost as well. We know that housing affects more than just our quality of our residential life. It affects our access to jobs, our access to healthcare, our access to parks. There is a whole spectrum of different resources that come with our housing locational choices. And when there are walls that are created and inscribed through different administrative procedures that separate people on the basis of identity characteristics, one of the most powerful tools for disrupting that is through our housing laws that facilitate integration. And we haven't gotten there, in all honesty, through the laws that we have available, but we're continuing to try. And I'm going to talk about some of the newer ways that we're attempting to do that. So that in a nutshell is our why. And I ask you as we navigate the remainder of this presentation to keep on coming back to this why in terms of thinking about your own communities, as you work within your counties. What patterns have you been experiencing or seeing with regard to the sale of housing? What information have you been acquiring about housing cost burdens or reports from tenants about their experience living? And what is the composition of your county racially? Where are people clustered? How are people separated? And so as we go through the presentation, try and connect the dots between the why and the laws and the conflicts and the best practices. So let's move into our discussion of the laws. So let's first address the issue of civil rights that occurred prior to the condition of civil rights prior to the Civil War. And we have some beautiful language regarding equality and freedom in our Constitution and our Bill of Rights. And yet, these early defenses of individual liberty had a notable exception when it came to race, that our Constitution and our Bill of Rights presumed, inscribed, and protected slavery and legalized racial subordination, so that whereas white residents, the citizens of America, were entitled to a certain set of individual liberties, Blacks were subject to the endurance of slave codes, and there was not seen a contradiction between the Constitution and the Bill of Rights and those slave codes. And moreover, citizenship and right of property was not allowed by Black people in this country. And the Supreme Court, as many of you may recall from your high school classes, in the famous or rather infamous Dred Scott decision, formally excluded Black people from citizenship. So this is the original sin, if you will, from which we begin our conversation. And it reveals the degree to which even the notion of fair housing was so far removed, if we couldn't even at this point think about the fact of applying basic equality and citizenship to our Black residents. So we start to experience change in the 1860s in the context of the Civil War. And here, first and foremost, we have the movement toward the abolition of slavery, beginning first with the Emancipation Proclamation of 1863 that provided freedom to slaves that escaped the Confederacy and crossed over into the Union. So if a slave escaped and they came into the Union, then they were granted freedom. And then we have full abolition of slavery that comes in 1865. But where we begin the dialogue about fair housing is in the Civil Rights Act of 1866. And this is the Act of Congress which declares all people born in the United States as citizens. Notice this is, a direct affront to the findings in the Dred Court decision that affirms that all citizens are equally protected under the law, and it grants Black people the right to enter into contracts and hold property. So this last line here about holding property is key because it really serves as the basis for fair housing, that it suggests that Black people are entitled to the same rights as white people with regard to their ability to establish a place of residence. The Civil Rights Act of 1866 is still invoked in federal lawsuits regarding fair housing violations. It's still relevant law. At the time of its adoption, there were folks who said that Congress did not have the legal authority to step that far. And so there was a movement in the 14th Amendment to establish that congressional authority. So you'll probably see some overlap in the language of the Civil Rights Act of 1866 with that of the 14th Amendment, which provides a broad definition of citizenship, which is not restricted to people who are white, that guarantees due process under the law and requires equal protection under the law. So echoes of the Civil Rights Act of 1866. And then some further civil rights laws under Reconstruction, including the 15th Amendment, which offered protections in terms of the right to vote, that it couldn't be restricted on the basis of race or color or previous condition of servitude. And then finally, Civil Rights Act of 1871, which was in many ways a response to the violent actions of the Ku Klux Klan and ensuring that there would be legal remedies available to Blacks who were subject to violence and harassment. So this is where we fell under Reconstruction in our efforts to A, bring the Union back together, B, abolish slavery, and C, finally begin a process of granting full equality regardless of race. It didn't entirely work. Between 1870 and 1964, segregation followed slavery as a method of controlling the residential locations, employment opportunities, and access to public space for Black citizens. We had a Supreme Court ruling in 1896, which upheld racial segregation under the theory of separate but equal, a notion which really didn't disappear until the 1960s, and that found manifestation through Jim Crow laws that enforced racial segregation in the South. But it wasn't only the South. There was also lots of examples in which segregation, both administratively and legally, were also inscribed in places such as New York State, for example, through the adoption of racially restrictive residential covenants that limited the sale and succession of property on the basis of race. We have a step forward in 1957 toward some modification of our civil rights laws, and specifically establishing for the first time some level of federal oversight with regard to monitoring voter suppression. But the 1957 Civil Rights Act doesn't really touch upon the issue of housing. That's going to happen in the 1964 Civil Rights Act. So it's under the 1964 Civil Rights Act that three things happen. First, we have an act of Congress which prohibits discrimination based on race, religion, color, or national origin in public places, schools, and employment. Secondly, we outlaw discrimination on the basis of those characteristics. This is under Title VI, but it also included sex with regard to employment discrimination. But lastly, it made it illegal for any federally funded program to discriminate on the basis of race, color, or national origin. And those federally funded programs would include those programs that were sponsored and funded by HUD, right? So now this is limiting because we're not talking about the full universe of housing. We're not talking about fair housing applied to county governments or localities or to private individuals or to the real estate brokerage industry. We're really talking here about the very narrow group of programs, but it's there, and it introduces the idea that you can't discriminate in housing for anything, for any type of housing that was created as a result of federal funding from HUD. Now, the Civil Rights Act of 1964's protective classes have been evolving more recently, partially as a result of Supreme Court rulings, which have attempted to provide protections on the basis of gender identity and sexual orientation by extrapolating the meaning of sex as a protected class to encompass protection also on the basis of sexual orientation and gender identity. And we also have more recently passage of the Equality Act in the House of Representatives. This was just last in February, that would amend the Civil Rights Act of 1964 to more explicitly provide protections on the basis of gender identity and sexual orientation. That hasn't yet been approved by the Senate, but it signifies the evolution that has been made about the 1964 Act. And as those additional protections come, they also would apply to housing. So we're in a bit of a wait and see on the Civil Rights Act of 1964. With regard to the Civil Rights Act of 1968.
Kevin, can I jump in here and just share my screen quick? For those seeking CLE credit, I have a code word that you will need to write down or type in on your CLE form. And that first word is cost. That's C like cat, O, S like Sam, T like Tom. Thanks. Go ahead, Kevin.
Sure. So finally, here we are. This is the moment, 1968, Congress adopts the Fair Housing Act 6 days after the assassination of Martin Luther King. And finally, 100 years after Reconstruction, we have a clear policy that protects people from discrimination when they are renting or buying a home, getting a mortgage, seeking housing assistance. And in the original conception of the act in 68, it offered protection on the basis of race, color, national origin, and religion. It applied not only to the federal government, as was the case in 1964, but applied to private landlords and real estate companies. It forthrightly addressed coercion and intimidation and harassment that interferes with a person's enjoyment of housing. Fair Housing Act says that cannot happen. And it also allocated responsibility for enforcing the Fair Housing Act to HUD. So this was key, because if you step back 100 years ago to the Reconstructionist civil rights laws, they sounded good, but there really were no administrative enforcement channels that were available. Yes, you could go to court, but the apparatus wasn't there for someone to be able to file a complaint and navigate the system. And finally, the Fair Housing Act includes language which directs recipients of federal housing monies to quote unquote, affirmatively further fair housing. Hold that thought. We're going to go deeper on that statement. But first, let's briefly just review the ways in which the act had become modified over time. In 74, sex is added as a protected class. In 1988, we have the addition of family status and also protections for persons with disabilities. And in 2012, almost 10 years ago, HUD already began to move proactively on including sexual orientation and gender identity as the bases for protection vis-a-vis extrapolation from sex as a protected class. And that didn't come through modification of the law. So we don't have yet sexual orientation and gender identity there inscribed within the federal code. But through the guidance from HUD, we do have that. Now, during the previous federal administration, there was steps moving backwards on that HUD guidance to fully encompass protections on the basis of sexual orientation and gender identity with regard to the Fair Housing Act. But shortly after President Biden's inauguration, HUD did distribute guidance that reaffirms and recommits the agency toward recognizing sexual orientation and gender identity as a protected basis within the Fair Housing Act. So we just covered the core of the federal laws. Let's move on toward talking about the state laws, because while we've got fair housing laws in place at the federal level and that would be used within a federal court of law, we also have other laws that might be used within a state dispute. And that includes the New York State Human Rights Law, which was adopted in 1945, so way before the Fair Housing Act. And this law, like the Fair Housing Act, it prohibits housing and lending discrimination and other forms of discrimination. It includes some of the same protected classes that were covered by the Fair Housing Act, race and sex and disabled persons. But notably, it does include some protected classes that were not covered by the Fair Housing Act, right? So we also have marital status, we have age, we have military status, we have creed, which is sort of dovetails with religious belief in New York State. Sexual orientation was added as a protected class almost 20 years ago in the New York State Human Rights Law. Gender identity and expression was added more recently, and just also in 2019 was added source of income, which makes it illegal for a landlord to reject an applicant for housing on the basis of the funding source they're going to use to pay their rent, which includes housing vouchers. So sandwiched on top of the New York State fair housing laws are the county fair housing laws, right? Now there's variation in the ways in which different counties have structured their laws. Some counties have closely tracked what's gone on in New York State. Some counties have legacies where they had moved forward on certain protected classes faster than maybe New York State. So there's variation in each of them. And I just sort of listed here as examples from Nassau and Suffolk County for you to see some of that variation. Suffolk County, notably, for example, includes status as a victim of domestic violence as a protected class. It also explicitly identifies veteran status, or alienage and citizenship too as protected classes. So in determining what is the level of liability for a violation of fair housing, you want to look at these protected classes at the county level. You also want to look, though, at the housing policies that may be inscribed in the county, because even though you have fair housing laws, you may also have, and this is not common, but you may also have some laws that relate to the production of housing within the county. And I don't mean a model inclusionary housing act that's encouraged for localities, but an across the board requirement, which is in place in Long Island under the Long Island Workforce Act. And what that does is it requires developers to make 10% of their housing affordable when they're constructing multifamily housing with more than 5 units. So they get something in exchange. They get a density bonus where they can build more than 10% over the permissible density under that locality's existing zoning scheme. And in all honesty, it's not a very high bar, or rather, maybe I should say a low bar with regard to how deep the affordability requirements go. You can get affordability at up to 130% of the area median income, which is rather high for Nassau County. And the developers have flexibility in terms of their compliance with the Workforce Act. They can build the required housing units as part of the development they're constructing. They can build it off-site, or they can instead pay an in lieu fee. So this requirement, alongside the human rights laws, at the county level helps to shape and inform how housing units, affordable housing units, are built and how they are geographically distributed. There are also city fair housing laws, and they sort of bear a similar pattern to the county laws. It's also the case that many localities, a reflection of their limited resources in terms of corporation councilors and capacity, may not have up-to-date federal housing laws, and they may actually just sort of rely upon the county and the state and the federal laws as the armature for determining fair housing. With regard to enforcement channels, as I mentioned earlier, we have now enforcement channels that are established within HUD, including ones that are available within its Office of General Counsel. But as county governments, I'm sure you're also familiar with the availability in HUD for funding programs that provide monies to local governments and counties, or alternatively nonprofit organizations, to be able to fund fair housing programs. There's a housing and civil enforcement section within the Department of Justice, and they often are they will take on the cases that relate more to patterns of discrimination, such as zoning and land use disputes. Within New York State, we have at the state level, we have the Human Rights Commission, and we have the Office of Attorney General. Some of you as counties, you may have human rights commissions, which are there to provide information of fair housing. Very often, the county human rights commissions do not adjudicate cases or research them, but you'll rather punt them to another level of governance, as is often the case with city human rights commissions. And then finally, when these sort of quasi-judicial remedies are not effective or useful, there is also the availability of the courts. So these are our enforcement channels. And then in terms of the ways in which the criteria for enforcement is set up, we roughly have 3 different standards. So the first one is disparate treatment, and this is the easiest one. This means that you can't treat someone differently on the basis of them belonging to or evincing an attribute of a protected class, right? So easiest example is the real estate broker. Real estate broker cannot direct a Black applicant for housing to one type of housing unit, but then only direct white units to another type of housing unit based upon presumptions of where that broker thinks that person belongs or where they'll feel more comfortable. That's a very clear example of disparate treatment. Disparate impact starts to become more muddy. Disparate impact is where we have a situation where a policy is not on its face discriminatory, but in its actual effect, it has a disparate impact on certain groups of people. I think the easiest way to convey the concept is actually not through housing, but maybe through employment. So for example, let's imagine you have a police department requirement that in order to become a police officer, you need to have a master's degree in criminal justice. And only applicants that have that master's degree in criminal justice are qualified for the job. And when we look at our educational credentials on the basis of racial demographics, and we see that maybe more than 85% of a population reflecting a certain racial attribute does not have a master's degree of any kind, and so therefore is disqualified for the job, we see that this requirement, though facially neutral, has a disparate impact on that party of people who do not have that degree. Now, the way in which HUD has interpreted disparate impact has evolved from a rather generous embrace of disparate impact in 2013 as the basis for administrative decisions and for the resolution of legal disputes on housing, to the retrenchment of disparate impact under the Trump administration, where they attempted to make it harder to prosecute disparate impact claims in the housing arena, to a more recent re-embrace of disparate impact with new rules expected to come out under the Biden administration's HUD department, and those rules are now currently pending in OMB. So I think we can expect a discarding of the retrenchment from the HUD rules from 2020 under Trump, and a reassertion and perhaps a softening of the requirements to invoke a disparate impact argument for discrimination. And then finally, we have affirmatively furthering fair housing, which, as I mentioned, was language in the Fair Housing Act, but didn't really begin to get addressed until '94, when HUD began to require grant recipients to conduct an analysis of impediments to certify their commitment to affirmatively furthering fair housing. And as part of that process, they had to show that whatever impediments to fair housing occurred, that they were proactively attempting to overcome those impediments to constructing affordable housing. What was missing from the analysis of impediments was a clear analysis that showed how housing policies might be perpetuating segregation or failing to fostering racial integration. Goals, step back to our initial conversation about why we need fair housing, that were part of the impetus of the Fair Housing Act in the first place. So in 2015, we have a new approach to affirmatively furthering fair housing that places the fostering of racial integration, the removal of segregation mechanisms from our housing sector, and the introduction of a new compliance requirement, the Assessment of Fair Housing, the AFH, to replace the AI as the methodological approach toward evaluating Fair Housing Act compliance, certifying a locality or counties or consortiums commitment to affirmatively furthering fair housing. The AFH never really got much traction. A few were completed in accordance with the methodology. The requirements to complete it were staggered. And then a new federal administration came into power and began a process gradually of dismantling affirmatively furthering fair housing. By 2018, compliance was suspended. For localities and counties recipients of federal funds, there was tremendous confusion and in terms of what you were supposed to do. Were you supposed to do an analysis of impediments? Were you supposed to do an AFH? Were you on hold? Were you not supposed to do anything? Were you in a waiting pattern? And for the most part, you really were in a waiting pattern, sometimes getting mixed communication from HUD about what the right thing to do was. Hearing that there would be some retention of affirmatively furthering fair housing, only in 2020 for HUD to basically come out and essentially eliminate it under the Preserving Community and Neighborhood Choice rule. We are now swinging back in the direction of 2015 and restoring affirmatively furthering fair housing's emphasis on the responsibility of governments to adopt housing policies that foster racial integration. But are we going to move back to the assessment of the fair housing methodology? Many of you are already right now in the midst of doing an analysis of impediments. So again, we're in a wait and see pattern here. What we do know is that, like HUD's disparate impact rule, a new rule is expected on affirmatively furthering fair housing. And we're going to be receiving greater clarification about the precise methodologies going forward that are going to be required and how the requirements will be staggered for different recipients. I realize that's not a satisfying answer to many of you who are trying to figure out what exactly are we supposed to be doing right now, or we're doing something, are we doing the right thing? But if you are in the midst of an analysis of impediments, I would say you are doing the right thing, but you should do so in a state of awareness about the federal government's renewed commitment to dealing with segregation and facilitating racial integration. So that concludes our section, part 1, on the fair housing laws. And now what we're going to do is we're going to apply those laws to 3 fair housing disputes. 2 were bigger cases because there was a resolution of them. The third case will be a shorter case study because we don't yet have a resolution. I suspect many of you are familiar with the first one, which was a highly publicized case that unfolded in Garden City community in Long Island. And there was a lot of press about this that came out at the time, but it was also renewed press about it during the time of the Newsday investigation into real estate practices. Garden City, a population of about 22,000 people, was primarily white, and it was neighbors with the village of Hempstead, which had a population that was primarily people of color. And with regard to Nassau County's economic disparities, what we saw overall in Nassau County was that the majority of households, who are lower income are folks who are African American and Hispanic. So this is the context in which the Garden City conflict that unfolded around 2006 emerged. These are the general statistics. A situation of segregation, a situation of economic disparity, and a locality, Garden City, which had no affordable housing and that had also declined to join the consortium of local governments that were recipients of HUD funnies and so would be therefore subject to affirmatively furthering fair housing.
Kevin, can I interrupt to give the second code word?
Please do.
The second code word is fair. That's F like Frank, A-I-R. Thank you.
Sure. So here's what happened. In May 2002, reeling from a shortage of monies, Nassau County attempted to address some of its fiscal issues by concentrating its county buildings and deciding to sell off its social service building, which was located within a civic area of Garden City. And at the county's request, at Nassau County's request, Garden City began a process of rezoning the site of the county's social service building, which at the time had been zoned for civic uses. A private planning firm, they developed a proposal to allow for multifamily housing. We could build as much as 311 units of housing on the site. That would help the county increase the value of the property. So the county was happy with that. And the Garden City Village Board accepted the zoning. Garden City residents were let me rephrase that. Many Garden City residents and vocal residents of Garden City were not happy about that decision to bring in multifamily. And through public hearings, they verbalized that discomfort, referring to their unwillingness to allow those people of certain types, low-income people, to come into their community, being declarative about their opposition to affordable housing. Statements which were responded to by the then county executive through reassurances saying, though there's multifamily housing, there won't be affordable housing. A context of public dialogue, which ultimately led the private planning firm to change courses at the direction of Garden City, retract its offer of multifamily housing as the best approach to rezoning the site, and instead downzoning the site to allow it for 96 single family homes or 150 townhomes and only 36 multifamily units. Nassau County, July 2004, issues an RFP. And the RFP is responded to by an affordable housing development group that offers to build as many as 2,000 units, 2/3 of which are affordable, and asks for a change back into the zoning to allow for multifamily. But Nassau County goes with a private developer for a market rate development with no affordable housing and predominantly low density for $56 million. Here's where we end up shifting from a planning battle to a legal battle. So housing advocate organizations file a lawsuit in May 2005 against Garden City, charging that the locality had violated the Fair Housing Act, the Civil Rights Act of 1866, Civil Rights Act of 71, and Title VI of the Civil Rights Act of 1964. They charged that because the proposed zoning was going to prevent affordable housing from being built by pushing forward a single family approach to development, that the new zoning would be unlikely to be occupied by minorities. But the plaintiff in this case also charged that Nassau County was liable too, and that this action and their participation in the zoning and disposition process was part of a broader pattern in which Nassau County was directing its federal funds from HUD toward affordable housing only in communities that were disproportionately minority, while not directing funds toward the building of affordable housing in areas that were predominantly white in terms of their racial demographics. So both the county and the locality are subject to the lawsuit. There is a long and complex procedural history involved here, moving from the district court, federal district court to the Circuit Court of Appeals. And we're going to bypass all those intricacies to just cut to the chase about what happened here in this case. And what happened in this case was that a federal district court in December 2013 ruled that yes, the proposed zoning, the down zoning, the change in zoning violated the Fair Housing Act and the Constitution's Equal Protection Clause of the 14th Amendment. And in arriving at this position, it determined that that had occurred on the basis of the racial animus that governed the planning choice. The sequence of events, the way in which public input had been used to change courses, the rapidity at which the zoning had been changed from multifamily to a single family approach, the way in which the land was disposed, the broader context. So this is how the federal district court came to its conclusion on Garden City. And it mandated a series of remedies, including the rezoning of the site for multifamily housing, or if it wasn't going to be made available for redevelopment, to allocate 10% of future multifamily in Garden City for buildings more than 5 units as affordable housing. They were required to do in-person fair housing training. They had to adopt a resolution promising that they would assure equal housing opportunities. They had to sort of make this pledge that they would not violate housing laws in the future. They had to hire an outside compliance officer, and they were required to join the NASA Urban County Consortium, which disperses federal housing and community development funds. So this is what happened to Garden City. But as county folks, I think you're probably more interested in what happened at the county level. Just have a little bit of a pause here on, there we go, okay. So let me be clear. The courts never determined that Nassau County was legally responsible for the change in zoning or had violated the Fair Housing Act. The plaintiffs had charged that the county would be liable because they were part of the disposition, because they had an opportunity through the referral process to reject the zoning, because they could have been more aggressive in their communication to Garden City about how the zoning was discriminatory, or because they could have found a way to bypass the zoning in terms of the disposition of the land. The courts weren't persuaded by those arguments, but the plaintiffs didn't give up. And even as Nassau County received summary judgment exonerating themselves from being part of this dispute, they never really were able to get a true ticket out of this. And so finally, in March 2019, Nassau County did settle the case. And as part of that case, they provided financial payments to the housing advocates. They promised to allocate a quarter of their home funds toward affordable housing. They committed to a development and outreach plan that would identify the locations of mixed income housing. They committed in their disposition process to identify RFPs for affordable housing, like Garden City too. They, committed to doing fair housing education, for their staff and for their localities. They also had to make a pledge to abide by fair housing. And they also committed to monitoring their local governments as they develop land use and zoning regulations and making sure that their localities complied with fair housing. So this is how the case ended with Garden City, and this is where we are today. And for the most part, I do believe that Garden City and Nassau County have complied with the terms either of the court ruling and or the settlement terms, though not completely, and some are still in progress. We're going to switch to our second case study here. And again, I think this is one that many of you are probably familiar with, and I realize we probably have some representatives here too from Westchester County who may know this issue very well. And the context for this dispute was that Westchester County, like many levels of government, received funding from HUD for its CDBG programs, and like other recipients of monies from HUD, had to conduct an analysis of impediments to fair housing. Well, in 2006, a nonprofit organization, the ADC, filed a lawsuit against Westchester County, claiming that Westchester County's certification of compliance with affirmatively furthering fair housing was incorrect, that it was actually fallacious, and that they had fraudulently accepted monies from HUD without really fully addressing race-based impediments to housing or affirmatively furthering fair housing. So what was the evidence that they cited of that? Well, they looked at what were described as higher opportunity areas that were disproportionately white, affluent, anchored by strong schools. And they noticed in these areas that, a very small representation of African Americans and Hispanics were living in them. And that in these areas, these high opportunity areas, there was not affordable housing. So given the fact that racial minorities are disproportionately lower income and in need of affordable housing, ADC charged that the practice of allocations of HUD monies constituted a perpetuation of segregation and an unfair denial of access to areas of opportunity through the deprivation of affordable housing construction in these areas. Those were the arguments. Now, there was a court decision that affirmed the validity of those arguments, but the actual outcome of the case was determined through a consent decree between the ADC and Westchester County and with HUD and DOJ, in which the county agreed to several terms. They would make financial commitments to affordable housing. They would construct units that specifically affirmatively furthered fair housing. They would promote a model inclusionary housing ordinance. They'd complete an AI analysis of impediments, and they would market housing to the populations that included large non-white communities that were living in the county or nearby. So those were the terms of the settlement. And in a way, Westchester County became a bit of the poster child for the fair housing demon, if you will, as a result of the press and publication and the result of the evidence that was marshaled here. And it took a while, in all honesty, for Westchester County to truly come to terms with the settlement. It also took a change in the administration at the county executive level. But in many ways, I think Westchester County has emerged as sort of a poster child for how to handle fair housing at the county level. They made their financial commitments. As of January 2021, they have completed almost all of the 750 units, with more units in the pipeline. They did promote a model inclusionary housing ordinance. No, not every locality adopted it, but they were aggressive in attempting to educate localities about the value of inclusionary housing. And they reprimanded them when they failed to do so. And they made funds contingent, HUD monies contingent on the compliance of localities to adopt these housing ordinances. Getting the analysis of impediments right took 8 years and 10 drafts, but eventually they got it, and HUD approved it in 2017. And they took a very proactive role in affirmatively marketing the affordable housing units that were built. They set up a website, they had a Fair Housing Expo. They just really stayed in the public eye and made sure that people were aware of the units and that they reached out to minority communities so that they were aware of the development of this housing. So that is where we landed, and this is where we are today with the terms of the settlement complete. Our last case here, and as I mentioned to you, this is a pretty short case, relates to the allocation of community preferences. And many communities have these on the books. And in New York City, it's a program that began in the 80s, whereby affordable housing lotteries were held in which the residents of a particular community district were given priority for the affordable housing units built in their own district. And there are folks that contend that this prioritization of existing residents for eligibility for these units is important because it addresses the housing needs within a neighborhood, because As neighborhoods in New York City become more expensive and residents are priced out, the affordable housing provides them with a protection against displacement. And because many lower income residents are disproportionately of color, it ensures racial equity. And then lastly, a lot of folks have championed community preferences because they feel like if they were taken away, city council members in New York City would not advocate as strongly for affordable housing in their neighborhoods or support it. Critics charge these are not convincing arguments. New Yorkers want to live where they want to live. They don't want to be segregated in their certain neighborhoods, in their existing neighborhoods. They take issue with the fact that this is actually going to be a bulwark against displacement because we're talking here about the introduction of affordable housing units, not market rate units. And while the racial equity argument is invoked by the advocates of community preferences, critics argue that what it actually does is reinforce patterns of segregation because it also means, for example, in a predominantly white community, should there be affordable housing units made available in that community, those units would go disproportionately to white residents, while Black and brown residents would not receive the same priority, thereby cementing long-standing patterns of segregation that go back decades, if not hundreds of years. So this conflict has manifested in a lawsuit by the same plaintiff in the Westchester case, the ADC, and they've made the arguments that I've just mentioned, and they've done no small amount of rather sophisticated statistical and geographic analysis to show the adverse impacts of community preferences in terms of depriving minority New Yorkers from access to affordable housing units in certain neighborhoods, and that the benefits of them getting advantages in certain neighborhoods are not offset by their disadvantages. This case is still pending, and I know just from my professional practice, no shortage of communities that are struggling so hard to figure out whether or not local community preferences is a good thing, that it's a good response to dealing with systemic racism, that it is a defense against displacement, or whether or not it actually does the opposite. And I have to say, there are some strong arguments on either side, and we don't have clarity yet, on what will happen in New York. But based upon what we know from outcomes in similar cases, such as in Oyster Bay, Long Island, based upon settlement agreements filed as recently as yesterday for a local community in Westchester, we are moving in a direction where local community, geographically based residential preferences are entering into a state of legal uncertainty and also legal liability that can trigger localities to end up being in court and to be subject to violations and remedies. So this is where we are. Might it change? Might we develop some more nuances? Yes, but we are moving away in a sort of de facto acceptance of community preferences as a progressive form of housing policy, as we introduce greater attention to the importance that fair housing practices deal head on with the perpetuation of segregation and find strategies to foster integration. So that concludes the second part of this presentation. And as I mentioned, I want to tie it together here and leave you with some concrete recommendations. This is not legal advice. This is me with my planner's hat of how I think county governments should move forward based upon what you've learned here on the law, based upon the outcomes of the courts. What are the best practices that counties should undertake? Well, there's 5 or 6 of them. First of all, I would say to you, go ahead and analyze your housing needs now. This is important. Do the demographic, the population analysis, find the impediments to affordable housing, analyze the housing gaps, look at the barriers, come up with a housing action plan. I know some of you are in the throes of doing this, even as you encounter some confusion about what will be expected of you in the coming years with regard to affirmatively furthering fair housing. But whatever but the bottom line is that your housing needs are an issue today. And so moving forward on it is only going to help you with your consolidated plans, with the precise formats of the AFFH certifications that are required. And the other thing I would say as a best practice is that as you analyze those housing needs, link it to your economic development strategy, do them simultaneously if you can, because the level of interdependence between housing as an economic asset and your economic development strategy, your fiscal strategy, are so intertwined. So that's best practice number one. And then we have best practice two. This is really a response to, this one is planning for housing supply increases and rehabilitation. And this is really a response to the case law. Go ahead, you were in a wonderful position as counties to identify the parts of your county that are ripe for multifamily affordable housing development based upon transit access or economic development trends, sectoral shifts, your awareness of the infrastructural environment, the availability of sewers, for example. You may be in a county where the localities are not going to do this on their own, and your assistance helps to put on the map, literally and politically, the value of identifying parts of the county that are suitable for multifamily affordable housing, and work collaboratively with them, work with them on trying to find the parcels that are right for it. The third thing you can do is help your localities to adopt and promote housing laws. Their housing laws may not be in a state of good repair. Your county laws, your human rights laws may be one. Some of you have been really good about this in terms of developing model ordinances on different topics, whether they be inclusionary housing or adaptive reuse or accessory units. When you have small communities with limited resources, the greatest chance they may have to get technical support on moving forward on these particular regulatory approaches to advancing fair housing may be from the templates that they inherit from you, and that they can then decide how to tweak and customize to make suitable for their own community. And then lastly, three more on funding for housing development. I suspect I may have confused some of you. It may sound from the case law that we're saying you shouldn't direct your money to low-income communities of color, and you should direct those money to quote unquote high opportunity areas. And at the same time, it seems like if you were to do that, you would be depriving resources that would help the revitalization of neighborhoods which may be disproportionately populated by Black and Brown and Asian residents. And the answer here is to be thoughtful about it. Align your funding allocations with your housing needs assessment. Think through all of the issues, the goals that are related to facilitating racial integration, the goals that are related to neighborhood revitalization. Map, memorialize, document how you're creating a diverse housing portfolio in service to a multiplicity of housing goals without rejecting one of them. And one way to compound that process is also to develop a very clear approach to how you would market affordable housing units. You can help localities do that. You can make sure that they're following the guidance from HCR and HUD. You can make sure that they understand how to reach populations that may be least likely to apply for affordable housing units. And you can make sure that they're not getting into the muddy waters of geographic preferences by telling them not to do it, or even conditioning your money, your federal and state dollars, on their compliance by avoiding geographic preferences in their marketing for housing lotteries. And then the very last piece that I'm going to close with, and then we'll address some questions, is the educational process. I think that this is powerful. And again, I just want to point out the work just over the last 2 or 3 years that Westchester County has done here in terms of bringing fair and affordable housing into very broad discourse through partnerships with localities and housing advocates and nonprofit organizations, and hosting symposium lectures and information sessions. That's very powerful. And in your responses to localities, as part of your referral letters, link it to the housing needs assessment from your county. Substantiate, your response to subdivision approvals or comp plan updates that may be overlooking or omitting multifamily affordable housing by showing the misalignment with county policy, which is a reflection of fair housing law. And then finally, the last thing I would say to you here is, don't wait until you're in court or subject to a settlement or consent decree of sorts to be aggressive with your localities about pointing out when they have made an error in compliance with fair housing. It happens. Just because a locality has adopted a certain rule or regulation doesn't make it legal. And it may indicate systemic racism. It may indicate the absence of legal counsel to advise them. It may indicate a misunderstanding about what's appropriate to reach fair housing. But you're uniquely positioned because of your access to resources, your awareness of the different localities to respond, to intervene. And back to Westchester, something that the court-appointed monitor stated in the more recent evaluation of Westchester County's compliance with the terms of the settlement. They pointed out, look, no, not all localities adopted a inclusionary housing ordinance, but Westchester County tried, and they documented it when they did intervene. And they did point out when there was a divergence from fair housing or from county policy or the terms of the settlement and the way that a locality was moving forward on their local land use regulatory environment. So that is the conclusion of part 3, housing best practices. And it's also the conclusion of my presentation. So from here, I will answer questions which may have arisen.
Kevin, thank you very, very much for your thoughtful preparation, your thoughtful planning and execution of today's CLE webinar. We all learned quite a bit. I know I did, and I'm sure I'm speaking for those that are viewing this webinar. We've learned quite a bit about the history, about the statutes, both at the federal, state, and local government level, and now have a better comprehensive understanding of how these laws and case precedences and agency guidance all interact with each other. So thank you very much. We will have your PowerPoint and slides that you presented today available for all of the attendees so that they can further use those, especially the best tips at the end that you suggested for county governments, which was absolutely terrific. So I'll stop there and just simply wanted to say thank you for, again, a very well organized and prepared session. We do have some questions coming in here now, and so I will pause and encourage all of you that are with us here to submit questions into the chat. We do have a few minutes for Kevin to answer some of these questions. And please, I'm sure everyone could benefit from what's on your mind, some of your questions, comments, or even concerns about what Kevin outlined. So I'll stop there and turn it over to Patrick Cummings. And Pat, we do have at least one question in the chat box if you wanted to go over that question.
Yeah, thanks, Steve. And again, to mirror what Steve said, thank you to Kevin. Thank you to all for joining us on this important CLE. We got a question coming in to you, Kevin, from Anthony in Orange County. How you doing, Anthony? Good to see you here. What does a county do where a community doesn't list housing on the MLS in terms of ensuring inclusive housing?
Right. So that's a good question, Anthony. You have to make use with the data that you have available. When there is MLS data and you're doing a housing needs assessment, it is really invaluable. You can really see the trends and track them really well. You can look at across geographic areas. But if you don't have that data, you can still identify the gaps in the housing inventory with regard to affordability by looking at other indicators. You can make use of the census data evaluation information. You can work with the localities and work with them in terms of the data they have available as part of their assessment and tax rolls. And then the other thing that you can do is look at the, from a qualitative perspective. A lot of times of what we do is we interview the housing developers, the brokers, and the residents themselves to really get an understanding of just how inclusive a housing market is. Especially we do that in cases where we're lacking in the data to fully measure the level of inclusivity with regard to the existing housing product that is out there.
Thanks. We got another one now from Aaron Cousins. I think she said, assessors get a monthly sales, oh, I think there's maybe a comment. Assessors get a monthly sales for the locality. And anybody else, feel free to jump in on the chat right now if you've got a question. If you think of something afterwards, you can always email us. We can get that question to Kevin. And or if you want to unmute your line right now, if you're more comfortable with that, we still have a couple more minutes.
Let me also say, you know, I'm okay with you if you, I'm in the book. So if you want to reach out to me directly with further questions, you can.
Maybe you could leave you can give the folks your email and your phone number, or
Yeah.
put it into the chat, whichever you prefer. But I think people would benefit from having that information, Kevin.
Okay, there's that. And I should also acknowledge the slide deck that you got yesterday was so close to being complete, but it was still a little bit in draft format, and I fixed a few typos early this morning. So if you want the latest and greatest version without the embarrassing typos, you're welcome to write me too, and I'll just send you. The content is the same. It's just a few cosmetic issues, and that's my telephone number too. So
If I can just remind everyone to please fill out your affidavit of attendance and your evaluation form and email them to me today. The forms are fillable PDFs, and you will have to open them up and save them to your computer, and then you fill them out, save them again, and you should be able to email it back to me without any issues. If you do, just please feel free to reach out if there's an issue with it.
And Lisa, where do they get the forms?
They were emailed to everybody yesterday.
Thank
I
you.
sent out an email with them attached, as well as the program materials were attached to that email as well.
Okay, I want to thank everybody for taking the time to attend this session here. Again, want to thank our speaker and expert presenter, Kevin Dworka. Kevin, thank you for everything, and I'm sure that you'll be getting lots of questions. We will continue to work with you on this subject matter over the year, and we're very grateful for your time and expertise. This will conclude today's webinar.
thank you for having me.
Thank you to